Today we're going to discuss about when the family-based green cards are not used, how do they come to the employment-based? In what proportion they come into? When would they come into? How the family-based unused green cards will be helpful for the business or employment-based immigration. Emily, we know that last year, because of the pandemic, some of the unused family-based green cards fell over to the employment-based. We have seen the priority date move all the way to even four years, though. That was only up to about 100,000 green cards that came out, and we're expecting 135,000 green cards to fall into starting from October of 2021. Can you explain how this process works, Emily?
Sure. Happy Ugade, everyone who's celebrating. It's your new year. Okay, it's very complicated and a lot of math. Basically, let's start with what the basic rule is. We have 140,000 green cards available for employment-based, and those are divided by the category. So EB1 gets 28%, EB2 gets 28%, and EB3 gets 28%. That's about 40,000 to each category. Then we have our 7% cap for any country that is oversubscribed, meaning they have more than 7%. If they would take more than 7% of that 40,000, they're cut off at 7%. That's 2,800 approximately. So for example, India and China generally oversubscribed for EB2 and EB3. They're cut off at 2,800 green cards per year. That includes family members. So 2,800 for India for EB2, 2,800 for India for EB3, 2,800 for China for EB2, 2,800 for China for EB3. So that's how the current system is set up. And then when we have the spillover from the family-based categories, let's say, for example, we have 100,000 extra green cards that are going to go to employment-based. Those are divided in the same proportion. So we have 100,000, 28% goes to EB1, 28% goes to EB2, and 28% goes to EB3. So EB1 gets an extra 28,000 green cards, EB2 gets an extra 28,000 green cards, and EB3 gets an extra 28,000 green cards. Now, on top of that, if there are any unused green cards in the EB1 category, they will spill down to EB2. And likewise, if there's any unused in EB2, they spill down to EB3. If there's any unused in EB4 and EB5, they spill up to EB1. So it's a very complicated, lots of moving parts. At the same time, I mentioned the 7% cap, but when you implement that 7% cap, so we have 2,800 for India, 2,800 for China in EB2, for example. That leaves, 34,000 green cards available for the rest of the world. Well, what happens when the rest of the world doesn't need 34,000 green cards? There's not enough applicants. Then those spill across to those 7% capped countries. So, and those spilling across is based on oldest priority date. So the country that is the most backlogged will get those green cards. So that is why, with all of this spillover from family to employment and the spilling down from EB1 to EB2 and the spilling across from rest of world to everybody else, we end up with Indians getting the bulk of these extra green cards because there's not enough people in EB1 to even use up the regular, 28,000 or 40,000, sorry. So those extra that don't get used in EB1 move down to EB2. EB2, there's not enough people to use up all 40,000 because the rest of the world doesn't use all theirs up. So then all of those green cards that spill down from family, down from EB1 and into EB2 spill across to those countries that are most backlogged, generally India and China.
So in other words, practically in the year of 2021, starting from October of 2020, that's when the USCIS year starts out. We are expecting that a good number of green cards to be given to Indian nationals. Normally, the unused green cards are given in EB2. They do gain a little bit of it. It's not 2,800 green cards every year. Normally, Indians get about maybe approximately 7,000 to 8,000 green cards every year in the EB2. because of the non-usage of the other country nationals, though. Now, since we have extra approximately 28,000 green cards in EB2 available this year, based on the formula, though, most of this, if not all of these 28,000 green cards, will be given to the Indian nationals. Not only this extra 28,000 green cards, but also the unused green cards from the 40,000 and unused green cards from the 28,000 that came into EB1 will fall into EB2 and horizontally to Indians. Indians are to be gained very significantly because of the family spillover. Now, this kind of spillover has not happened ever before. In my practicing of immigration from the past 25 years, it never happened. Obviously, you guys all know that the pandemic never happened in the past 25 years. It was somewhere, I don't know, maybe 1916 or 1920, somewhere around that period of time the pandemic occurred. Now, we don't know about the immigration laws then, but at this point of time, out of the 100,000 green cards that are spilled over into this year, I would say anywhere between 90% of them should be going to Indian nationals, though. Now, coming to the next year, the the State Department has announced that at least 135,000, somewhere around 135,000 green cards will become spilling over to the employment-based. So actually, Emily, the COVID is turning out to be a boon for at least the Indian nationals who have been waiting for a long period of time to get the green card. Not that I would like to continue with this COVID, but it ends up that a lot of the Indian nationals who are waiting for the green card are going to be hugely benefited. So people need to plan. If you have not filed the green card, you may want to file the green card immediately. If you have already filed the green card, stick with the company that has the labor certification so that you can avail the chances. It's a good chance that the visas are going to move way, way forward in October of 2021. So please be aware. Anything else to add, Emily?
No, I agree with that completely. Be ready for October.
Now, we told that, yes, a lot of 100,000 extra green cards, but still EB2 priority date is May 1st, 2010. What do you call it? Do you expect anything in the May visa bulletin?
Yes, I mean, the filing dates chart is not expected to move again until October, but the final action dates should start to speed up to where they will hit the filing date by September. So wherever the filing date is right now for EB2, that's where
May 1st of 2011.
That's where EB2 should be. However, this does not take into account downgrades. So the more people that downgraded to EB3, EB2 could actually jump beyond that final action date, and EB3 may start to slow down.
So EB3 also, even though the filing dates was until January 1st of 2015, they did adjust the filing dates to be January 1st of 2014. So most probably EB3 might advance, though, but we are expecting that the spillover happens more to the EB2 than that of the EB3. So EB2 may advance more in the month of May visa bulletin, though. We're expecting it probably in a week or 10 days. The visa bulletin, we're expecting EB2 to advance very more, though. Any updates on the consulate appointments, Emily? Now, we have seen that the pandemic is going very heavily in India. In fact, three of our colleagues in India have gotten the COVID. What's going on in the consulates there? It's what's going on.
Yeah, there was an announcement, when was that, on Friday, that the Mumbai consulate had to basically cease all operations due to the COVID infection rate going on there. At that time, they did say that the other consulates were not impacted, but remember, all the other consulates are not even operating at normal levels. They're only handling emergency visa situations anyway. So this is just going to continue to extend the backlog and the waits for people who have been waiting for their visa interview appointments for some time.
At this point of time, we have not seen any cancellations other than the Mumbai consulate, especially in the US consulates in India. They are going through, no cancellations have been notified at this point of time. The Dropbox definitely is going through fine right now, especially in the, other than Mumbai consulate, the Dropbox is going fine right now. We have to keep watching these things very carefully. If you're planning to travel, though, for the visa stamping, you may want to be very careful. Check our YouTube and Facebook a week before you make any travel plans, because this will be keep updating every week based on the situation there. Even though right now they may be entertaining the appointments there, they may not entertain appointments at a later time. It will depend on the local situation of each consulate. We have noticed that the Maharashtra government has put a lot of restrictions. They may not be applicable to the US consulates, but consulates do honor, especially these kind of health emergencies that arise. So they will adjust to the local governments and try to comply with as much as possible with the local government rules, even though they're not obligated to. But they try to comply with those things. So each week you have to monitor. We would recommend that you keep coming to the Facebook and YouTube and try to ascertain the facts before you make any move before you make a move to go to the consulate appointment. On the employment-based green card, so a lot of people, especially the people who came after 2017, 2018, Emily, they never thought that they're going to get the green card. Believe me, I have a lot of my cousins, nephews, nieces, they come in, and then you told them, and we all told them, it's going to take 100 years to get the green card. Obviously, some institutions said we are wrong by 50 years. They said it's not 100, it's 150 years. And they proved us wrong. They have all the stats to prove us wrong. So it was a debate was whether it was 100 years or 150 years. Now, all of a sudden, it's 2015, the priority date moved, and then we're expecting it to move much further. What does people need to do to get the green card? The main thing is that please start the green card process as early as possible. I mean, maybe on student visa. There are ways that you can start on student visa too, especially if you're not Indian national. That's the best way. You can avoid the H-1B completely and get the green card too. If you're Indian national, Chinese national, we still strongly recommend that if you want to obtain the green card, the better is to start the process as early as possible. And if your employer is not willing to sponsor you for the green card though, that's when the time you need to determine, they don't like you at all. I mean, that's the reason you have to determine. You may want to move if your skill set is in demand, and if your employer is not offering you the green card, it's time to move on. I mean, you can move on to a different company that is willing to offer the green card. So starting very early is important, and also be watchful on the things that if you are in the process of the green card and you are in the middle of the green card, don't try to change the company. Wait until the I-140 is approved. Wait until 180 days is passed after the I-140 is approved. Then at that point of time, I want you to evaluate carefully, is the move worth? There are a lot of people that come into our daily Zoom call conference that we conduct. If anybody wants to attend it, you can check our timings at rnlawgroup.com. They want us to evaluate, is it worth moving? I'm getting $50,000 more, I'm getting $100,000 more. Is it worth moving? For me though, being an immigrant that came and waited for the green card to get it, money, I mean, that amount of money, especially $50,000 or $200,000, is not worth for me. I want my green card. I want to get rid of Rahul Reddy and Emily in my life. I mean, you don't want to be coming into this conference, listening to this YouTube. You want to get the green card and become free. And that's a good thing, is that you may have to sacrifice a part of your profession, a part of the money that you will be making extra if you join a new company, so that you get the green card and then you will be set free. These are my advice. Anything else to add, Emily?
Yeah, I think that right now the job changes are the trickiest part, especially because with changing employers, you have to start the perm process over again, and that's taking 18 months.
Wait,
you're setting yourself back 18 months.
Labor certification was only taking 3 months. What are you saying?
Yeah, now we've got prevailing wage taking at least 5 months, and then the processing time of the perm is like 7 months now, plus the advertising recruitment phase has to be done as well. So you really need to plan 18 months for that whole process to be done so you can get to the point of filing your I-140. And we're talking about dates moving in October. Well, that's not 18 months from now. You're going to end up missing the boat. And we don't expect this same thing to happen in October of 2022. We're not going to have that same family-based spill down.
Why can't you expect the same thing in 2022, Emily?
Because we don't have the travel ban anymore. What started this whole thing was the family-based travel ban, which of course, now that travel ban is gone, we still have consulates not operating completely, but they are opening up and processing family-based green cards now. Those are considered to be in the national interest for some of these countries that are still under different travel restrictions due to COVID. So the number of family-based green cards being used up is going to continue to increase, which means that less spillover would be available starting from October 2022.
And do not forget that COVID is not expected to stay here until 2022. Hopefully so, it won't stay. So the spillover might not occur every year. There are times where I've seen that to move the priority date from one day to another day, it took 7-8 years. Tell an example of it. In April of 2012, the priority date for EB2 was April 1st, 2010. That was the final action date though. Guess what, after 9 years where it is? Same level, April 1st of 2010. So when this pandemic is over, I mean, we know that filing dates are more, we're expecting the final action dates also to move. But sometimes they move back, guys. The dates move back. It is absolutely so important for you guys to be in the 485 stage. You will have freedom of moving from one company to another company. You will have more freedom to change from one location to another location without filing any amendment. You will have freedom of not getting the stamping when you go outside the country by using the advance parole. You will have the freedom of not filing the H-1B. You will have the freedom of not filing the H-4 for your dependent. You will also have the freedom of working on the EAD extension, especially on the 485. Once you have the EAD and you file the extension, you can work while the EAD extension is pending. And whenever you want to change the company, all you need to do is that file a 485J supplement, and the filing fees for that is zero. So even if you don't eventually get the green card immediately though, to be on the stage of the 485 is absolutely important. And if I were you guys, I will make the sacrifice so that I don't have to pay all these, somebody doesn't have to pay all these huge legal bills and a lot of filing fees. Sometimes the filing fees are $6,000. And every time you go, you have to get the stamping. Oh, pandemic is there, the visa is there, this is canceled. Who knows you're going to get the visa or not? Sometimes you don't even get the visa stamping. All those things can be avoided if you are able to file the adjustment of status, also called as I-485. So please be watchful about this, and I want you guys to make sacrifices to get to the 485 stage.
Killa from Facebook has a 485 in progress, no biometrics yet, and wants to know if she can travel now because she has a valid H-1B, and is it okay to switch jobs at this point? So regarding the travel, if you do have the valid H-1B visa stamp and you're not going to a place that has travel restrictions of coming back, you could potentially travel, but there's some risk because what happens if the biometrics appointment comes while you are outside the US and you're not able to make it back in time?
And there are no flights in between.
Yeah, and you have to reschedule, and they only allow you to reschedule so many times before they deny the 485 for abandonment. So that is a risk. I would recommend waiting until the biometrics are done and then traveling. As far as switching jobs, you need to qualify for AC-21 in order to switch jobs without negatively impacting your pending 485. So that means you have to have an approved I-140. Your 485 has to be pending for 180 days. The new job has to be same or similar to your job that you were sponsored for, and your new employer has to submit the 485 Supplement J. I actually just wrote an article about qualifying for AC-21 today. It's posted at rnlawgroup.com in our news section. Talks a lot about what exactly needs to happen for the job to be considered same or similar. What happens if it's a promotion? What happens if the salary is different? What happens if the location is different? All all of those are addressed in that article, so you may want to check that out on rnlawgroup.com.
Shahil from YouTube has this question: what are the chances of Rand Paul Believe Act passing? Sahil, there are 70 immigration bills right now. We are not paying attention to each and every bill, though. Especially a bill coming from Rand Paul, a Republican senator from Kentucky, without support of the Democrats, has less chance of approval. So we're not going to focus on 70 bills, read everything, go to the bottom of it. So at this point of time, we're not giving that much importance to that bill.
Surrender from YouTube is planning to file the H1, H4, and H4 EAD next month, but his spouse's passport is expiring in April 2022. He wants to know, will that impact the H4 or the H4 EAD approval end date? When you're filing with USCIS, the end date does not get impacted by an expiring passport, so they can still approve your H1 extension, your H4 extension, and your EAD extension for the full 3-year period. Where the passport expiration becomes an issue is when you travel and your passport is expiring before your I-797 approval notice. They will likely cut short your I-94, and you have to get the new passport and travel again, or get the new passport and file an extension early in order to avoid any out of status or unlawful presence time.
Raja Viramatu from YouTube has this question. My son's I-94 expired on September 28, 2020. We just noticed it, and it's been over 6 months that the I-94 has expired. Raja, I'm assuming that your son is under 18 years old. If that's the case, the consequences are not that bad. Either way, Raja, I would recommend that you contact a lawyer. There are 2 different ways of correcting this. You can file a non-proton case, or you could have the kid leave the country and get the stamping approved. But it all depends on the age of the kid. If it's under 18, though, the solutions are very easy. If the kid is above 18, there are some hard choices you have to make. I would recommend that you contact a lawyer. Just in case anybody wants to speak with me, Emily, or any of our colleagues, you can always go to rnlawgroup.com. You can make an appointment there. And my schedule and Emily's schedule and every other lawyer in our office schedule is available. You can block the timings at any point of time that you want to. And you can give the details for which you are contacting us, or upload any documents that you want us to review, so that when we are at the appointment, we can look into the things when we are speaking with you.
Kishore from YouTube wants to know, he's planning on submitting the medical exam through the Interfile option that we've talked about a number of times on this show. He wants to know where to send it. Does it go to the National Benefits Center, the National Visa Center, or local office where the case is going to be interviewed? So you have to first look at your receipt notice. There should be in the bottom left corner an address for the service center or location where the application is pending at right now. But before you go with that address, please check your online case status once to make sure that the case has not been transferred to another service center or to the local office. If it's been transferred, you're going to have to send it to the new location that it was transferred to.
Question from Red Rav 4. Can I change the employer as soon as we get an EAD and EAD approved and EB3 downgrade I-140 approved? Is there a chance the employer can revoke the EB3 I-140 because he did not stay for more than 180 days after the I-140 is approved? You don't have to wait until 180 days after the I-140 is approved. You can change to a different company. One thing, Red, that I did not notice in is that if you have crossed the 180 days after filing the 485 application, if it's 180 days after filing the 485 application, and if your new employer files the 485J supplement, and you can read the article Emily has written at rnlawgroup.com, to qualify for the 485J. Mostly, it's not that hard to qualify for it, but I still want you to read that article she posted just now. And if the new employer files a 485J supplement, it doesn't matter if your previous employer withdraws the I-140. Some people say they cannot withdraw. They can withdraw, but it would not affect your green card. You would still get it. But I want to make sure that you file the 485J supplement, because if your employer withdraws the I-140 approval and there is no 485J supplement, you will have a hard time in reinstating your 485. You may have to go to the court, and you have to spend a lot of money to get reinstated. I would recommend that you avoid that circumstances and file the 485J supplement.
Kumar from YouTube wants to know if we can share insights into the processing times for those AOS applications that were filed this fiscal year. Is it really realistic to expect all of those extra green cards from last year to actually get used up? The Texas Service Center processing times are super slow right now. It's a great question, and we've definitely been wondering that, but we do see USCIS taking some actions in order to reduce processing times and try to get through the applications that have current final action dates. We saw that many applications remained at the National Benefits Center rather than been sending to the Texas Service Center or the Nebraska Service Center, and National Benefits Center has been issuing the EADs, and then in some cases they're approving the application without it ever being transferred to the local office. They're sending the RFE for the medical if that wasn't submitted, and then they're ready to approve it without doing the interview. So I think if USCIS continues those actions, they should be able to get through them all. I do think with this administration, they're very aware that they don't want green cards to go to waste if they can avoid it. So I'm hopeful that they will get through them all.
In fact, I'm noticing, Emily, that even though the adjustment of status that we filed after March of 2017, the Trump administration said that they have to go through the interview process. Even for EB3, we have a lot of approvals without going through the process. Also, some of the cases filed in October, I would say Nebraska Service Center though. Sorry, not in Nebraska, in Phoenix lockbox though. We have some cases that got, where the EB3 was current, they got the green card. Some, very rarely though. They got the green cards when the final action date is current. So things are going, and this interview waiver process that is really going on. In EB1 we're noticing it, EB3 we're noticing it. They are getting the green cards without interview, which is taking most of the time. So if they continue with this path though, I think so they will be able to use a good number of, if not all of those green cards that are spilled over into the employment based.
Elvis from YouTube has a visa stamp expiring in June of 2021, but an I-94 that's valid until April of 2023, and wants to know if he can continue working for that employer until April 2023. So the visa stamp expiration date and the I-94 expiration date are two different things. And the visa and the I-94 serve two different purposes. The visa that's in your passport is what gets you in the door to the United States. So you use that at the port of entry. So the visa has to be valid when you're entering the U.S. Once you're in the U.S., you are given that I-94 through the CBP website. The I-94 is what controls how long you can stay in the U.S. So based on what you're telling me, your status is valid till April 2023, even if your visa is expiring in June of 2021. But please verify that with the attorney that you're working with, because there are some weird situations where an I-94 is given for the wrong date. Especially we see that in L1 situations with blanket petitions. So you want to make sure that the I-94 is accurate, but assuming that it is, then you can stay beyond your visa stamp expiration.
Saurav Jain has this question from YouTube. He wants to switch a job as soon as the I-140 is approved. Can he use the priority date in the future and I-140 for the H-1B extension? If the main question, Saurav, is will the I-140 be withdrawn by your company after you leave the company? If they don't withdraw within 180 days after you leave the company, you can use that I-140 to file the extension. and also use the priority date reporting when you move to a different company. As a cautionary method, because the things what you cannot control is whether your employer is going to withdraw or not. Most probably, 99.9% of the time, if you stick with the company until 180 days, they will not withdraw the I-140. So I would take that extra precautionary method of staying for 180 days after. And if you go to the first 7 minutes of what we spoke in this video, it will explain you also another good reason why you should not leave the company within 180 days after the I-140 is approved. Questions are coming with regards to those people whose priority date is 2017 or 2016, 2017, 2018, 19. Should they file the downgrade to EB3? This was pointed out about 1.5 years ago or 2 years ago in our video that it's not needed for you to downgrade at this point of time. You may request, you may test the waters with your employer to see if they are willing to downgrade it. As long as they're willing to downgrade it, you don't have to do it. If you remember, Sudhir, what happened is that in October of 2020, a lot of employers have filed the downgraded applications to EB3 and file adjustment of status. There are some companies, especially one of the top, couple of top consulting companies from India, though. They're based out in India and they are consulting companies here. They did not downgrade. But most of the companies, even huge companies in the United States, they did downgrade. So at this point of time, what is important for you is to see if the company is willing to downgrade to the EP3. If they are willing to, you don't have to do it. You can do it when the time comes.
Uma from Facebook has a spouse who is in H-1B status with the max out date of February 2022. The company is going to be filing PERM in November of 2021 and wants to know if while the PERM and I-140 are in process, can she switch to H-4? Yes, that is absolutely an option that allows her to stay in the U.S. While awaiting the I-140 approval so that she can then switch back to H-1B and get a 3-year H-1B based on the approved I-140. Just be aware that currently the processing times for the change of status to H-4 are quite long, so that can make it a little tricky getting back to H-1B, but hopefully by the time you need to do that, the processing times will have improved.
Question of the day. Mr. M or Ms. M, what is the I-485 processing time if applied after the final action date is current? It's about 5 months. It is 5 months. What the heck are you speaking about? Look into the USCIS processing time for the employment-based. It says anywhere between 2 to 4 years. In practice, though, it is 5 months. Believe me, it is 5 months. That's the reason why Emily and I was insisting with the question of the Texas Service Center, though. Yeah, there is a good chance that all these green cards that we have available may be used because the processing time, once the final action date is current, is very, very fast. They are pulling out. And here is another thing, what they're doing is that for the people whose final action date is, guess what is happening with them? The EAD is getting rejected, the advance parole is getting rejected. And normally our office doesn't like the rejections, but we like these kind of rejections. You know the reason why they are rejecting? Since your green card is approved, we're going to reject your advance parole and EAD. I like it. That's what is happening. They are not wanting to waste their time on approving your green card, on approving your EADs and advance parole. You don't need them if they approve the green card. So these are the good steps that the administration, especially the change in the administration, has drastically affected. There's a good chance that the things will be processed very soon if the final action date is current.
Ravindra from Facebook has a question on cap gap. He's working on OPT that's going to be expiring June 30th, and his H-1B was selected this year in the lottery, but with a different employer, not one he's currently working for. He wants to know if he's eligible for cap gap. So as long as the employer who received the selection notice files the H-1B before your OPT expires and requests a change of status with an October 1st start date, you're eligible for cap gap to work for any employer that meets the OPT requirements. So if you're on STEM OPT, that means they need to be an E-Verify company and they do the 983 training plan. It does not have to be the same employer that is filing your H-1B petition.
Narmata has this question. My spouse is currently in India. Can I include him when filing the 485? No, you cannot. To file the 485 application, your husband has to be here, Narmata. Otherwise, you can't include him in the 485 application.
Nistu from YouTube wants to know if we have any updates on the EB3 downgrades for physical therapists. This is Schedule A, where you are not required to have an approved labor certification in order to file the I-140 petition. I don't have any news of approvals. I also don't have any news of denials, but I am getting reports of people receiving RFEs or even a notice of intent to deny, asking why the prevailing wage determination is expired at the time of filing the I-140 petition. So we've yet to see the results of these types of RFEs. It's unclear whether this is just one officer or if this is a trend, but we'll definitely keep you updated as we have news on that.
And if your application is pending, at this point of time, I would not like to do the premium processing. I want to have the USCIS establish a firm policy before I convert into premium processing. Maulik from Facebook has this question. Is the I-944 required when applying for I-485? Thank Biden. No, we don't need it anymore. Yes, that was a big nightmare for us when we did the 485 application in October of 2020. But thank Biden, we don't have that anymore.
Priyank from YouTube wants to know if we have any update on the class action lawsuit filed for the H4 and H4 EAD. We know that preliminary injunction is planned to be filed. They're working with the court on that process and working with the government to get to some agreements on that. It may not be necessary. Well, you just have to wait and see at this point. But that's kind of the next planned step, is to file a preliminary injunction if necessary.
Vivek has this question. What is I-485 and how long it takes it for you to get after the I-140 approval? Well, you have to go to the basic. There's something called priority date. There's something called filing the adjustment of status once the priority date is current. There is called filing dates and final action dates. I think so you have to educate yourself a little bit more, because the level of this YouTube is to the people who are a little bit more knowledgeable, though. We don't go to the fundamentals here. We just go to a little bit more advanced level people to educate them.
Bikram wants to know, can an H-4 applicant extend an I-94 based on the H-1B's approval notice by going to the border and then use that to file the EAD? So I'm assuming you're referring to automatic revalidation?
No, that's not what he's assuming, Emily. There is some rumor going on where people have people are saying that you go outside the country, show the H-1B, and come back with the extension of the H-4, though. Mm-hmm. We have seen in very, very rare scenarios, I would say out of every 100, maybe less than 1% of them, I would say 1% of the time I've seen them giving the I-94 that is valid, especially if they're traveling actually from outside the country, not mostly from Mexico or Canada, but mostly from India. Let's say if their passport visa is expiring in September 2021 and their husband's H-1B is expiring in 2024, I've seen in very rare circumstances that I-94. This is not what they're speaking about, automatic revalidation. I would not recommend that you guys travel there for this until it is confirmed that CBP, Customs and Border Protection Unit, is doing those extensions on a consistent basis. I don't want you to make a trip there.
Yeah, I was going to say they're not allowed to do that because you need to have the visa stamp because you don't have your own I-94. Automatic revalidation requires your own I-94. Otherwise, you do need to have the visa stamp. So those few people that are able to do that, it has been in unusual circumstances or by mistake. But generally, CBP is not allowing that. You have to have your own I-94.
Robin Singh is asking, so it is 100K green cards for 2021, 135K for 2022. Yes, you're right. I mean, the way we start the 2021 starts on October 1st of 2020 for the USCIS. So for 2022, it starts on October 2022. The 135 is not an official figure, but this is expected green cards that are going to roll over from the family-based immigration to the employment-based. Robin, don't forget that we do have 140,000 green cards that are naturally already there for the employment-based. So it's going to be 140 plus 100,000 for the year of 2021 and 140 plus 135 for the year of 2022. But when it comes to the Indians, though, typically they get about between 15,000 to 20,000 because they have a 7% limit. But they get all the unused green cards for the EB1. So approximately 15 to 20,000 green cards go to the Indian nationals every year in the 140,000. But when it comes to the extra 100,000 green cards, they may get 90,000 of them on top of the 15 to 20,000 they get it. When it comes to the 135,000 green cards, it may be all 135,000 green cards will go to Indians. If not, at least 120,000 green cards will go to the Indian nationals. So we do expect a lot of movement for the Indian nationals prior to date in the coming months.
Raul from Facebook wants to know how much time is the normal processing time for I-140 petitions right now. I would say anywhere from 4 to 8 months is pretty standard at the service centers.
Questions that are popping up are very controversial, Emily. Emily, what is your prediction for the prior to date movement in October of 2021 for EB2 and EB3?
I gave a prediction earlier, and now I can't remember what it was, but it was less than 4 years.
You said 2016.
Yeah, that sounds right.
I said 2018. There you go, they're quoting us. But if you don't believe what she said, don't believe what I said, guys, please. We both have gone wrong many times in predicting the prior to date. I, in particular, will claim in front of all the internet that I have predicted prior to date more wrong than anybody else. And I have evidence to prove that.
Mukesh from Facebook wants to know, can we file the H-4 EAD based on an I-539 receipt? So I'm assuming you've already filed the H-4 extension and now it's still pending. You want to file the EAD. I mean, technically you can do that. Just be aware that because they weren't filed together, you're very likely to get an RFE on the EAD application asking for proof that the H-4 has been approved. And that RFE can delay the EAD by probably 2 months as it takes you to respond back to that and for them to process the case. So you may not be gaining a whole lot by doing that, just depending on how long your 539's been pending.
A lot of people ask questions with regards to the prevailing wage and also processing time for the perm processing. One thing is that we're expecting a little bit improvement in the processing times for the prevailing wage and also for the perm processing. The reason is that Trump administration increased the prevailing wages for the perm labor certification. And then the court comes in and says, no, you can't do that. Before Trump administration went back, they switched around and looked into the loopholes and republished those regulations, and the prevailing wage went up. And then the Biden administration comes and he says, pauses all those new regulations. So it's like new wages, old wages, new wages, old wages. The Labor Department had to work so hard in those times. And that's one of the reasons why the whole delays occurred. We are not expecting that delays to continue, so we may expect some forward movement in the time limit for the prevailing wage and also for the form processing time.
Jay from Facebook wants to know, is it wise to travel outside the U.S. to have a standalone H-4 visa stamp in order to bypass the biometrics and then travel back to the U.S. and apply for the EAD? And which country is the right choice? Pre-COVID, yes, we were seeing a lot of people doing that, and it was working well. Now that we are in COVID pandemic, we have a problem with consulates not operating at 100% capacity, and so it may take you time to get that H-4 stamp. You may end up running into travel restrictions getting back into the U.S., depending on the situation in the country that you're staying at. So there are definitely risks there. There's no guarantees that that will actually speed up the process. It does avoid the biometrics, which tends to be what has caused all of these delays, but you may face other hurdles in getting back into the country.
A lot of people are asking questions with regards to the I-140. One question is, if the I-140 is still pending and the final action date is current, what will happen? Well, the USCIS cannot give you the green card if the underlying I-140 is not approved. Then there comes question, I filed a premium processing, it got rejected, they told me to wait 30 days. Do I have to wait 30 days? Well, you can file it. You don't have to wait for 30 days, you file it. If they reject it, you wait for, you file it again. There's no rule that you have to wait. It's just a suggestion that you wait, but you don't have to follow that rule at all. You can file since there is no rule that exists. With regards to whether or not you should do the premium processing for the downgrade application, unless your kids are teenagers who are born outside the country though, if I were you, I would file the downgrade application. I would do it. A lot of people say, are there expectations of more RFEs because you filed the premium processing? No, that is not a true statement at all. If you file the premium processing, you will get an RFE. If you were supposed to get it, you will get in advance. That's all it is. I would rather want to get my decision right now rather than wait for a couple of years and get the decision. And one other point that I want you to let you know, that don't be fooled by the processing times of the I-140 though. Sometimes when it comes to when you have used the labor certification again to file the I-140, that means that you use the labor certification to file AB2 and you filed again for AB3. The processing time is quite different than the normal processing time what you see online. So don't get deceived by that. I would strongly recommend, unless you have a teenage kids, go ahead, file for the premium processing.
Ashwin from YouTube has a priority date in 2012 and wants to know if he can change locations to a different state with the same employer. Does that mean he needs to refile the labor certification? So assuming that you have not filed a 485, that means you're not qualified for AC-21 to take the green card with you to the new location. If your green card, your labor certification is based on a labor market test in your current location and that job is no longer going to be in that location and moving to a different state, your labor certification is no longer valid and it does need to be refiled. They have to test the labor market in the work location where the job offer is actually at.
On the biometrics update though, not all the people who have filed the 485 application got their biometrics. So please, have patience. There are some people will say that, well, my friend filed on October 25th, I filed on October 5th, but he got biometrics and I did not. That's normal, it depends on the officer. It happens, it depends on, sometimes it also depends on where you're located at also. Because some of the places, the biometrics places are open, some of the places the biometrics are not open frequently. I said somewhere in Delaware, somebody was telling that, or I don't remember the exact state, they're saying that there's only one biometric, they open only one time a week. And there's a lot of delay in that particular location. That's a survey that I got it from for people like you. So it also depends on your location. I've also noticed recently that new biometric places have sprung up. And one of my client vendors, they don't even know how to do biometrics. They got very confused. So that's a good news in the sense that they're opening more biometric places. So which is actually good. They may fasten it going forward. Previously, the biometrics used to happen, at least we used to get the notices within 30 to 60 days, we used to get the notices to go for the biometrics. But now, as I said, that even the people that filed in October are still waiting for the biometrics.
AJ from Facebook wants to know, can the priority date retrogress once a priority date becomes current? That is possible. It happened quite a bit over the years, and that's one of the reasons why we have the filing date chart. In 2015, the Department of State started having this dual chart system to try to eliminate the whiplash, they'd call it, of priority dates, final action dates going forward and back and forward and back. So they push the filing dates forward, and then they tell us we can't use the filing dates once they receive a sufficient number of applications, and that allows the final action date to just keep slowly plugging away, and that avoids the final action date going backwards. But it's still possible because all of this is based on their predictions and how many applicants they think they'll get based on where they move the date. But if they end up getting too many applications because they misjudged it, they can push the date back if necessary.
Narayana Babu Reddiwari from Facebook has this question. Can folks start using 485 EAD while the primary applicant continues to maintain the H-1B? Yes, they can use it. Absolutely they can. I know your name, Mr. Narayana Reddy Babu Garu, that we do have a separate conference call just for clients only. So you can drop an email. We have created it recently where you can come and chat with me rather than not getting a chance here. You will get a chance there. So drop an email to me. I will give you a conference call where weekly once we conduct a conference call where you can ask questions. You will get your chance every time there, unlike here.
And Patty from YouTube wants to know, do we have any update on the American Dream and Promise Act of 2021 that included benefits for dependent children that were at risk of aging out? So this is Biden's immigration plan. Oh no, that's not Biden's, that's the other one. With all of these different immigration bills, I think that right now the Democrats are very much looking at using the reconciliation process to move them forward rather than the normal legislative process. And we have a couple of bills that have actually passed the House, but they're not being taken up in the Senate. And I think the American Dream and Promise Act is one of those. And that may be because they're trying to go ahead with Biden's more comprehensive plan through the reconciliation process. But everything's kind of stuck right now. We talked about that last week at the beginning of our session, if you want to look back at that.
Abhijit has this question, and this question came many times before. He's saying that in the labor certification, it said masters are required. Will it create any problem in downgrading the I-140? Let me tell you the answer, Abhijit. No, no, and no. And here is the reason though. All we are telling is that when we are filing a downgrade application, that the position's minimum requirement is bachelor's degree. If master's is a requirement, bachelor's is easy. It's just like this. Somebody is able to lift 500 lbs. Now we are telling that the same guy who can lift 500 lbs can lift 300 lbs. That's it. I mean, I'm assuming every guy who can lift 500 lbs can lift 300 lbs. There are other requirements of financial capabilities, other things, but it's not that tough to prove that. Just because it says master's requirement doesn't mean that the downgrade will be denied. We have done several times, we never had any problem.
Mohit from Facebook wants to know if a person can still get an H-4 EAD after getting the green card EAD. There's no restriction on that. You can have both EAD applications filed at the same time and get 2 EAD approvals. Every once in a while we see some weird questioning of that from USCIS, but you're able to apply in both categories. You're not stuck to have to pick just one or the other.
A lot of people are asking about EB1C's premium processing, H4 EAD premium processing. Unfortunately, the USCIS has not implemented the bill that's passed at this point of time. We have no idea at this point of time when they would start implementing that. They haven't put it in the proposed dates when they will start implementing that, so we have no idea when they will start implementing it.
Imran from YouTube wants to know what happens if the final action date becomes current and the I-140 downgrade is still pending. So assuming that you did an I-140 downgrade standalone where you have not filed the 485 yet, if the final action date becomes current based on that pending downgrade, you can file the 485. No problem with that at all. If your 485 is already pending and your final action date becomes current, USCIS will still move towards working on your 485 and getting that ready to approve, but they can't actually approve it until the I-140 gets approved first, so it will delay the approval of the 485.
Tejinder Singh has a question. The L1A extensions processing are taking a long time. Yes, we do acknowledge it. But why can't you do premium processing? I mean, I understand, it's better to do premium processing. And it's always better to get the decision before your current L1A expires. So let's say, for example, if your L1A is expiring in May, if you get a decision right now, and if you get a denial, you can file one more extension. But if you get the denial after your I-94 expired, then you may have to leave the country and apply it outside the country. To avoid that, it's better to do premium processing and get a decision before your I-94 expires.
Mahesh from Facebook did the downgrade in October 2020, already received the EAD and AP, but the I-140 is still pending. He wants to know if they should go for premium processing of the I-140, and will we get biometrics, because that has not happened yet. You can absolutely do premium processing of the I-140. It has no impact on the EAD and AP processing time, no real impact on the 485, and it has no impact on the biometrics. The biometrics are tied to the 485, and that has completely separate processing from the I-140 itself. So you can go ahead and do that premium processing, but it's not going to cause them to issue the biometrics on your 485.
Deepthi has this question that can an employer apply for an I-140 when the person is on the H4 EAD? Yes, absolutely. They can apply for the labor and I-140 while you are on H4 EAD.
Tuhina from YouTube has a spouse filing a transfer, an H-1B transfer, but the H-4 EAD is still in process based on a previous application. H-4 is stamped, and wants to know what happens to the EAD application after that transfer is completed. So the EAD will continue to be processed. You might get an RFE on the EAD asking for the spouse's proof of continuing maintenance of status. We especially see that if the old company withdraws the H-1B approval that the EAD is filed with, but you should be able to reply back to that with the new transfer receipt notice or approval notice and pay statements to show that your spouse is still maintaining status, and the EAD should be able to be approved.
Praveen is asking questions. His priority date is January 2015, EB3. What are the probabilities of the filing dates to be current in October 2021? Very good probabilities, but don't take it as a guarantee. Very good probability, that's all I can tell.
All right. Well, I think we're about out of time for today. Thank you so much for joining us. If we did not get to your question, remember we do have a daily Zoom call that Rahul does, and you can get the schedule for that by going to rnlawgroup.com. And you can always schedule a consultation with us or any of our attorneys by going to rnlawgroup.com as well.
Thank you very much.